What's going on, gang? Welcome back to the channel. My name is Julian, lawyer and content creator, and today we're going to be talking about transactional law versus litigation. Some of you guys have asked me to give you an overview of the different areas of law, and I thought this would be a great place to start because these are the two largest genres of legal practice that we see today. And while they're very different, they do share some similarities, so let's get started. First of all, at a high level, let's start with the why underlying each of these practice areas. Why does one person litigate? Why does somebody do transactional work? What are the purposes of these areas of law? Now, for litigation, this answer is pretty straightforward. Litigation is probably what you think of when you think of a lawyer. It's the process of suing another party. And that means doing research, making filings with the court, oral arguments with the court, negotiating for a settlement, selecting jurors if a case goes to trial, arguing a case in front of a jury, cross-examining witnesses, memorizing the rules of evidence, all of it. But at its core, litigation is violence in the law. It is the way that you can use the law as a weapon to attack another party. Between citizens, this could look something like a harassment case. Perhaps somebody sexually assaulted their neighbor, and now that neighbor is suing them for the emotional harm that the harassment created. Or it could be in the government context, like when local prosecutors go after a murderer for their crime and try to get them behind bars. Now, there are a whole bunch of reasons why people sue each other. So litigation encompasses a lot of different types of law and areas of law. For example, you could be a patent litigator, and the only cases you're going to be working on are giant lawsuits between various companies or individuals suing over who has the rights to a patent or whether a patent is being violated or infringed on by another party. Think Apple versus Samsung for the iPad or an iPhone. You litigate because your client has typically been wronged, and the way that they want to be righted or remedied is by going after the party that wronged them in the court system. And the only way to do that, if the other party isn't willing to put their hands up and immediately give your client what your client wants, is by suing them. That is why you litigate. Now, on the flip side is transactional law. And this is what I practice. By the way, if you need a transactional lawyer, especially if you're a content creator, a small business, or an individual, reach out anytime. I offer free consults. But transactional work is in some ways the opposite of litigation, because transactional work is trying to use the law as a proactive tool to look ahead and avoid litigation arising between the parties. What this most often looks like is drawing a complex contract together for a business deal or for a settlement agreement, for example, that the parties have come to. The hope is that by having a well-documented paper trail that outlines the various remedies and circumstances that each party has to follow, that the parties won't come back down the line and claim that one party or the other is violating the agreement and now the only solution is to go to the courtroom. You've probably heard me say this before in the channel, but when you get into a lawsuit, the only people that really win are the lawyers. So transactional attorneys are there to help you avoid getting into those lawsuits in the future, and also making sure that they're dotting their I's and crossing their T's in the business deal that they're handling. For example, in my practice last year, I helped one of my startup founders sell various pieces of their business to another person who wanted to buy them. The things that I wanted to make sure of in this agreement, and when I drafted this document for him, the things that I wanted to make sure were clear were the purchase price, when the funds were going to be due, the fact that liability would not follow the seller, aka my client, if this buyer ended up using these assets in some nefarious way, and other general contract clauses like the governing law, like the jurisdiction of choice clause, severability, and some other legal mumbo jumbo we don't need to get into details about. But the point is that transactional lawyers work to get a deal done. That's the core of being a transactional lawyer. And getting the deal done usually means making sure all the terms are right, making sure your client is protected, and trying to get ahead of any issues that could potentially create litigation in the future. So at a high level, we've discussed that litigation is suing each other and the act of fighting in the court system, and transactional work is the act of crafting complex documents to make sure that transactions are going according to plan and also trying to prevent litigation. A more important query for you if you're trying to decide which area of law you want to practice is probably, what does the work actually look like and how does the work differ between these two fields? So let's get into it. And I gotta tell you, they could not be further apart. I'll start with transactional because that's what I practice. Transactional lawyers typically follow a process like this. They get a client that needs a contract done. The lawyer, me, will go into all of the contracts that I've worked on before, and I find one that's as close as possible to the current deal that I now need to draft a document for. Then I'll modify the deal terms in this contract. I'll change the names, I'll change the dates, I'll change the terms. Sometimes I'll draft custom provisions, I'll delete some unnecessary provisions, and then when all is said and done, I have a beautiful, brand new customized deal document for my client. Once I send that deal document over to the other party's attorney, they'll negotiate some of the provisions, they'll delete terms, they'll add terms, It goes back onto my plate, I do the same thing, and eventually we reach a consensus and we make sure that the document is signed by each party. Everybody's happy, I get paid, life goes on. Most of my time as a transactional lawyer, as you can tell from that example, was spent drafting the document, negotiating the deal terms, and managing the work process and workflow of getting the deal done. That last component, managing the deal flow, that is a huge part of what a Silicon Valley attorney's job is when they work on venture capital financing, which is what I used to do in part at my old firm. Usually, and I say that because there's all sorts of different transactional types of work out there, but usually there isn't a ton of research involved when you're doing transactional law. To the extent you do need to do research, it's probably in the context of public company governance issues or bankruptcy. In those cases, for example, if you're a bankruptcy attorney, you need to understand the bankruptcy code, you need to look into past cases that might be similar to yours, and you have to do research kind of similar to litigation, which we're going to talk about. And in the public company regulatory context, for example, this is something I used to do at my old firm, Wilson Sonsini. When you're reviewing a public company document, you need to make sure that it's compliant with all of the various Securities and Exchange Commission's rules and regulations. That in turn requires you to go into the regulations and read up on the guidance or see if other companies have done things similar or different to you. But note that even when you're doing research on the transactional law side, it's not as dense and detail oriented necessarily as the litigation context, where the research typically involves diving into case law and reading the facts of several different cases and how the courts ruled on them and the reasoning and the justification, and then tying all of that into a memorandum or a brief. Instead, the research component is fairly limited, and your main role as a transactional lawyer is getting the deal done, which means drafting the documents, staying on the various counterparties, the opposing counsel, the opposing parties, your own client, to make sure that you're shepherding the deal forward and bringing it to a close. And the last bucket of transactional legal work that you should know about, and this is pretty similar to something called doc review on the litigation side, but it's due diligence. And due diligence typically entails poring through hundreds, maybe even thousands of a company's records or documents to make sure that there are no red flags, like missing signatures, or perhaps the company failed to adequately increase the employee stock option plan, which is the pool of shares that employees can get granted stock from. So then you as a corporate lawyer will go in through all of these records and make sure that you find any of these glaring mistakes or errors. Now, on the litigation side, take everything I'm about to tell you with a grain of salt, because while I do a little bit of litigation in my practice, it is not my predominant area of expertise. But generally speaking, your role is to win lawsuits on behalf of your clients. And what that looks like on the ground is a lot of legal research and brief writing. And when I say legal research, I mean LexisNexis, I mean Westlaw, I mean Bloomberg Law mainly. I'm more of a Westlaw guy myself. It's diving into case after case after case. It's looking into all of the details and the procedural history of how these cases ended. It's taking all of that, consolidating it into your head, and drafting briefs that outline exactly why your client and your fact pattern align with whatever the legal remedy is that you are seeking. So think a lot of research, a lot of writing. I definitely think that there's more critical thinking involved in the litigation context rather than the transactional law context. Because reading through all of this, and especially through the process of writing out the brief, that requires a lot of brain power. But in addition to the reading and writing, it's also the act of advocacy itself. And that takes the form of oral arguments in front of a judge or a jury. It takes the form of cross-examining witnesses who are on the stand in the trial. It takes the form of strategically finding expert witnesses who can help substantiate your client's case. This means a lot of public speaking, a lot of thinking on your feet, and a lot of preparation. The corollary to this on the transactional law side is probably negotiating a deal term on behalf of your client. But that's very different than going in front of a jury of your peers and arguing for your client's case. And of course, it's entirely different than knowing the rules of evidence and being able to contest what the opposing counsel tries to bring up to support their client's case. At the same time, litigators are probably the most quintessential lawyers that exist. That is the core of being an attorney. Many say that these qualities of oral advocacy, thinking on your feet, strategizing, preparing, that is the core of being a lawyer. And look, if you go all the way to the highest tiers of our legal system, to the Supreme Court, that's what these people are doing. They're making oral arguments in front of the court to get literal constitutional law interpreted in a way that they prefer. They are not sitting on the phone negotiating a term with the Supreme Court. At least not yet. That's not to say that transactional law isn't as cool, right? It's different strokes for different yokes. But if you're seeking the honor and the glory of being a lawyer, you're probably going to find it in litigation. Last piece of workflow in litigation, and that is doc review. Doc review is very similar to due diligence on the transactional law side. It's pouring through all of the facts and the case files that are provided to you for you as the lawyer to figure out, okay, which facts are important for my case, which ones should I include in my briefs, which are irrelevant, and is there a diamond in the rough here that can help me win my client's case? For example, did the other party commit financial fraud, and did I find that email that alludes to the fact that there might have been fraud that was committed? That's what doc review is meant to do, and doc review, similar to due diligence, is most often handled by a junior associate or a junior lawyer. Now, what about the money? Money. You might wonder if one area of law is paid more than the other. In my experience and based on my research, no. Both litigators and transactional lawyers are paid very well, and your pay is actually going to depend more on how you practice law. You know, are you a solo practitioner? Are you a partner at a big law firm? Rather than what kind of law you practice, aka are you a litigator or do you do transactional work? Both can be and are very lucrative. The only nuance that I'd add is that there are some plaintiff attorneys that chase crazy big cases like class action settlements, for example. And these are the lawyers that make the most money out of the entire profession, because if these attorneys are successful, they're able to negotiate settlements in the hundreds of millions of dollars. And typically they get a percentage of that, anywhere from 20% up to 40%. And if we're talking about a $500 million settlement on behalf of hundreds of thousands of people, then that lawyer and that law firm can walk away with hundreds of millions of dollars. The last thing I want to touch on when you're comparing these two areas of law is the lifestyle. You know, when I was in law school, I didn't necessarily know much about transactional law. But after my 1L year and going through the process of legal research on LexisNexis and drafting this brief, plus the specter of what litigation would feel like because it was so conflict driven and antagonistic with the other side, personally, transactional law sounded a lot more fun and happy to me. I would still get to use my critical thinking skills. I would still get to advocate for my clients, but it wouldn't be, at least to me, as stressful as being a litigator where you know the other side is trying to outdo and outfox you at every possible turn. And to give you an idea of what I mean, here is law talker Reb Maisel, huge fan by the way, you should go follow her, she has awesome content about the law and she's very entertaining, talking about her experience as a litigator.
Hamburger, fucking help me. How do you handle the hate online? Like, how do you handle the hate on TikTok? I am in a field, I am in a profession where I have literally heard someone, a lawyer specifically, be told in a courtroom by a witness that they look like someone set them on fire and put them out with a chain. At their day job, not only am I paid every day on an hourly basis to do my job, I'm also paid to fuck up someone else's ability to do their job. Doing my job and fucking up someone else's job is sometimes the same thing, okay? I want to ruin someone else's day, professionally, typically, normally, sometimes people's personal days. Sometimes we don't discriminate, right? But the issue with that is that the other side of my fucking fence, okay, is someone who's paid to do the exact same thing to me. Every single day they wake up and they type emails with malicious intent.
See, that doesn't sound very fun to me personally. I don't want to wake up every morning knowing the other side is basically trying to kill me in my career. But that is very much the spirit of what litigation is. Like I said earlier in this video, litigation is violence in the law. So when you're thinking about making this decision, think about the role of each of these attorneys in areas of law and how that's going to impact your psyche and your stress levels and your mental health. Because many people, like Reb, can thrive in the litigation environment despite its somewhat aggressive and conflict-driven nature. But many other lawyers, like myself, know that they wouldn't be happy doing something like that. And one last thing, how happy you are as a lawyer is probably going to depend a lot more on what your role is as an attorney. For example, are you in-house? Are you a solo practitioner? Are you at a big law firm? Rather than the type of work you're doing. Because being a solo practitioner, transactional lawyer, for me, for example, looks and feels tremendously different than what working as a transactional lawyer in big law felt like. And the same goes for transactional lawyers who go work in-house at companies like Google or Lyft or Uber. So my 2 cents is think about what you like, think about what you're good at, and then go for it. Because no matter what type of law you want to practice, there is a fulfilling legal career out there for you. All right, everybody, that's it for me on this video. Thank you as always for spending your time with me. I'm eternally grateful for it. If you enjoyed this video, please share it with a friend, smash that sub button, leave a comment for other content that you're curious about, and I'll see you next time. Be well.